So I'm going to talk this morning about researching across the four nations of the UK. So the United Kingdom of Great Britain and Northern Ireland came into being in 1921, some 2 years after the Sex Disqualification Removal Act 1919, which permitted women's entry into the legal profession for the first time. The Act was to amend the law with respect to disqualifications on account of sex and had UK-wide implications. It covered professional qualification as a lawyer and other aspects of the legal system, such as jury service. Whilst there may have been at the time of the passing of the Act one Parliament based at Westminster, the Parliament of the United Kingdom of Great Britain and Ireland, there were in fact several legal systems within the UK. The first women lawyers to qualify faced some common challenges as entrants into the legal profession, but also faced unique challenges within each legal system. Next slide, please, Marion. So why research across the UK? Developing and understanding the rich legal history and culture of each of the UK's legal systems helps to bring a fresh perspective into the journeys of the first women lawyers and those that followed. Next slide, please, Marion. However, whilst we know more about the lives of many first women lawyers and there is a greater understanding of their experiences of practice in academia and the prejudices they faced, there is more to explore, and a comparative approach looking across the UK itself helps highlight similarities and differences, not just in terms of becoming a member of the legal profession or academia, but setting their lives in the context of the different legal cultures, their different identities within society, and how their work has since been celebrated and recognised. Beyond those who qualified, there are also the lives of ordinary women who encountered the law to consider, women like May Donoghue, whose experience helped shape and influence the law. And underpinning all of their experiences are the historical and deep-rooted legal cultures which echo through the centuries, shaping each nation and the UK itself. And for reasons of time, what follows is deliberately inward-looking, focusing within the UK. Next slide, please. So we have a question of terminology when we're researching, and one aspect of researching across all nations is the UK Parliament. Terminology varies. So, for example, the Parliament based at Westminster in London has undergone several role and name changes, but has been commonly called the Westminster Parliament. Its representations from the nations has also varied, with the result that one culture often dominated. How this influenced legislation around key changes, for example, the right to vote and access to the legal profession, is unclear. The UK's legal systems have evolved over the centuries, and how many we have today depends on the viewpoint you take. There are 3 recognised systems and 4 legislatures, with growing calls for a separate legal jurisdiction in Wales. However, history can sometimes prove very difficult to forget. For example, undergraduate law students in England and Wales studying the legal system of England and Wales are still taught English legal system, and that is the shorthand still used by many publishers. I will come to the discussion about Wales and the infamous Encyclopaedia Britannica entry for Wales see England shortly. More widely, this is similarities to the way that the United Kingdom itself is sometimes miscalled England. Public perceptions around English common law are maintained, yet this serves to cloak the rich and diverse legal history of the UK itself and that of each of its 4 nations. This has not assisted cross-jurisdictional discussions and debate or consideration of that wider picture. Next slide, please, Marion. There are several key historical events common to all 4 nations, and, as in recent times, not all 4 agreed on the same course of action. History differs from the viewpoint of each nation, though imperial history often trumps all. So let's consider very briefly a few key events. In 2015, the anniversary of the Magna Carta was celebrated and discussed widely. There were aspects of the Magna Carta, however, which received little attention, including the chapters on the grievances of Scottish and Welsh rulers. It is also said to be the first document in which both English and Welsh law appear together. It also showed and highlighted the sharing of political ideas between Wales, Scotland and England in relation to appealing to the principle of judgment of peers and believing that dispossession without lawful judgment was illegitimate. There is also the Commonwealth, or, as is frequently termed in the history books, the English Civil War, but, as it should more commonly be known, the Wars of the 3 Nations, which divided Great Britain. Scotland and Wales took the side of the Royalists, and Ireland suffered a devastating fate at the hands of Cromwell. There was also the Scottish case of McCormack and Lord Advocate, in which a challenge was brought as to whether Queen Elizabeth II was entitled to be Elizabeth II in Scotland, as there had never been an earlier Elizabeth reigning in Scotland. It was claimed that there had been a breach of the 1707 Act of Union. The court held that the treaty had no provision concerning the numbering of monarchs. It was part of the royal prerogative, and therefore there was no title to sue the Crown. Then moving on to voting rights. The Representation of the People Act 1918 gave the vote to all men over 21, and some women over 30 also get the vote. A separate act allowed women over 21 to stand as MPs, which meant that young women could become MPs even though they were not in fact eligible to vote. In 1928, the right to vote was extended to all women over 21, and in 1969, the vote was extended to all men and women over 18. But now it is possible to vote in Scottish and Welsh elections at the age of 16, but the age of qualification of 18 remains for UK general elections. A considerable difference in time frame when compared to the time it took for all females over the age of 18 to be given the vote. An understanding of the history of each nation and the different viewpoints helps provide context for the diversity and cultural differences in relation to law, identities, and responsive, which helps set the context for research. And in exploring these, it is helpful to keep an open mind and challenge some of our own assumptions. As Raymond Williams wrote in 1975, the feeling for the past is more than a fancy, but it's about how past and present relate that tells in a culture. And this is particularly true when considering legal culture. Next slide, please, Marion. I would just like to introduce a brief overview here to set in context the position of Wales. The Acts of Union 1536 to 1542 passed by Henry VIII legally incorporated Wales into England and brought Wales under English law. At a time when most of the population spoke only Welsh, it was decreed that English was the only language to be used in courts of law and that people using Welsh would be disallowed from holding public office. A contradiction for a king whose claim was based on an unbroken ancestral line going back to the 7th century Welsh ruler Cadwaladr the Blessed. The Wales and Berwick Act of 1746 created a statutory definition of England. Mention of England now included Wales and Berwick upon Tweed, which led to the infamous Encyclopaedia Britannica entry that Wales see England. However, Wales retained a separate legal identity until 1830 through the Courts of Great Sessions. There were significant attempts to eradicate Welsh as a language. Speaking Welsh was often punishable by job loss, and there was the practice of the Welsh knot, where school children would be punished for speaking Welsh in school. They would wear a wooden plaque with the letters WN, and whoever was wearing this at the end of the day would often be punished, more often than not, by caning. Since 1837, births, deaths and marriages have been registered in England and Wales, but it took until the early 1970s before they could be registered in Welsh. And interestingly, the Act that allowed them to do that mentions Wales and Monmouthshire, although Monmouthshire had been part of Wales since the Acts of Union. So in 1919, it became possible for women to qualify and work as a lawyer, but it was not possible for them to work in the medium of Welsh. Welsh was not used in court until the Welsh Courts Act 1942, which limited use of Welsh to instances where the speaker would have been disadvantaged by having to speak English. The Welsh Language Act 1967 finally granted the right to testify in Welsh in the courts, and the Welsh Language Act of 1993 officially put the Welsh language on equal footing with the English language within Wales. And perhaps its history is the reason why Welsh has often been portrayed as the working class language and not the language of the ruling classes. I mention language as when researching records in Wales, those kept in Welsh may tell a different tale from those kept in English. Next slide, please. Thinking about sources across the UK, there are many diverse sources, both in the public and private spheres, and some are common to each of the legal systems, but the history is often written and rewritten by the victors and generally by men. Oral traditions, memory and local myths also feature more in some nations than others. Growth in research around 100 years has revealed a rich and complex range of sources which intertwine both legal and historical research. As part of the 100-year celebrations, for example, universities began to look through their archives, for example, see those of UCL and Glasgow. Chance discoveries led to recognition. For example, the chance discovery on eBay of a postcard featuring a portrait of a young black woman in university robes, which led to Aberystwyth University honouring one of its alumni in 2060 by officially naming a room in honour of them. Iris de Freitas, the first female lawyer in the Caribbean. She had qualified with the degree of LLB in 1927. A greater recognition of the role played by diverse groups emerges, and discussions around how identity is shaped. Care needs to be taken to ensure that heritage is not misinterpreted or misrepresented. The lives of the first women lawyers were difficult and challenging, both in professional terms and in the changes within which wider society was experiencing across all four nations. To challenge both the perception of the perceived role of a female and tradition was no easy task. Lady Ray, in an interview recorded to celebrate the centenary, noted, "A woman is emotionally unsuitable for court work. This was possibly the remark which drove me. It was made in 1972. In terms of the narrative, the stories of each nation are emerging from the historical dominance of the term English, and the term English is being recrafted in much the same way that historical narratives were once rewritten to justify elected George and his ascension to the English throne. In February 2015, when the Welsh Economy Minister Edwina Hart at a global summit noted the fact that Wales has a very long history of innovation when it comes to the development and delivery of law, it may have been a surprise to many in the audience who are probably unaware of the existence of Howells. It is clear that the Normans were not keen on their neighbour's legal system. It was one which recognised the rights of women and where laws were based on compassion rather than punishment and an emphasis placed on compensation. They had been codified in around 1242, drawing on custom, civil law and Roman law. Marriage was considered an agreement, not a holy sacrament. Divorce was permitted by common consent, and illegitimate children received the same rights as legitimate children. These are probably the laws which scandalised Norman England most. In Norman England, it was inconceivable that a woman or illegitimate child should have rights. The Archbishop of Canterbury told the Welsh princes that the laws were in defiance of the gospel and inspired by the devil. Having set some context about legal systems, I now want to turn to some of the first women lawyers across the UK's nations and the legal challenges some were forced to bring and which laid the foundations for the opening up of the legal professions. There are common features both in the challenges they faced, the cases they brought, and the length of time for which they continued to form a minority within the profession. In terms of common features, they occupied a lonely position whilst leading the way for significant change. Despite the idea being welcomed by some members of the legal profession, the professional bodies themselves were extremely reluctant, and the same tactics can be identified in several cases. It is difficult to identify which of the rules of statutory interpretation taught to law students today were employed when persons were seen not to include females. It seems that whilst there was an acceptance that laws could develop, there was no consensus about how the professions could become representative, and a wide range of excuses not to allow women into practice were used. Legislation was finally needed to break the barriers. And when reading around the topic, it is striking how often clothing, their bearing and appearance are commented upon, and an emphasis placed on the fact that they must have been clever. The Scotsman noted in its obituary of Isabel Sinclair that when requested by the Dean of the Faculty of Advocates to remove her nail varnish, which he considered unsuitable dress for court, she responded by suggesting he remove his side whiskers, which she disliked. The nail varnish remained. For many years, female lawyers faced hostility both within the professions and more generally, and there were issues over practicalities such as changing rooms and whether or not they should adopt wigs as court dress. Despite that hostile environment, progress was made in expanding their numbers, although it wasn't until the 1970s that the number of female entrants into the legal profession significantly increased. The challenges that began over 100 years ago continue. There is a substantial attrition rate. Many women do not go on to be partners or QCs, and in the judiciary itself, there have been slow, although steady inroads. In a recent interview, Lady Carmichael noted that she was enormously grateful to the women lawyers of the last century, and particularly the 10 women appointed before me as Senators of the College of Justice, for the part they've played in making it easier to progress with real confidence that all roles in the legal profession are open to women. Researching early women lawyers has in many ways taken its initial footsteps. We have clearer narratives about what qualifications they achieved, what cases they heard, how long they practiced for, and many of the challenges they faced. Information has been gathered which is now being placed within its wider context, a context that reveals the realities and complexities. And that context includes not only the branch of the legal profession into which they were admitted and practiced, but also the place and the nation in which they practiced. Thank you for listening, and I will end the talk there.